Hi, I'm Joel Williams, attorney here at Williams Elleby, and I want to talk to you for a few minutes about a type of case we handle called medical malpractice cases. In Georgia, a doctor must bring to the exercise of his profession a reasonable degree of care and skill. If he doesn't and an injury results from that, you may be entitled to a recovery. Several studies have shown that 70 to 80% of medical malpractice jury trials result in a defense verdict. Medical malpractice cases may be the toughest type of personal injury case to win. Now, there are two reasons for this. Number one, lobbying groups for medical malpractice insurance companies convinced the Georgia legislature to pass laws protecting hospitals and doctors and to discourage medical malpractice claims. Number two, quite simply, most people don't want to believe that their doctors make mistakes. The truth is that most medical professionals care very deeply about their patients. They're also skilled. But however, no one is perfect and mistakes do happen. These mistakes do not always amount to malpractice. For a doctor to be liable for malpractice, he or she must breach the standard of care. This means that doctors must exercise such reasonable care and skill for their patients as is ordinarily employed in the medical profession under similar circumstances and conditions. In cases arising in Georgia emergency departments, plaintiffs must prove gross negligence by clear and convincing evidence. So how can you prove medical malpractice in Georgia? How do injured patients prove their doctor breached the standard of care and committed malpractice? In Georgia, this is done with expert testimony. Malpractice cases usually require expert testimony from someone in the same profession as the negligent doctor, setting forth the applicable standard of care and how it was breached. Now, Georgia law requires that the expert be someone who regularly engaged in the practice or teaching of that area 3 of the past 5 years. In most cases, the plaintiff must include an affidavit from the expert when they file the lawsuit. Anyone who files a medical malpractice case in Georgia must pay careful attention to the requirements of OCGA 911-9.1 because it is the statute that must be followed regarding expert witnesses and affidavits in professional malpractice cases. Now, medical malpractice cases can arise from the negligence of doctors in many areas, including anesthesiology, surgical errors, foreign objects that may be left in the body, misdiagnosis, delayed diagnosis of cancer or infections, bed sores, nursing home negligence, medication errors, birth injuries, laboratory errors, battery or intentional acts, or unauthorized treatment, or failure to report child abuse. In most Georgia medical malpractice cases, you will need a top medical malpractice attorney who can bring a lawsuit within 2 years from the date that the malpractice occurred. The 2-year limitation does not apply when a physician leaves a foreign object in a patient's body or misses a diagnosis. In those cases, you must bring the lawsuit within 1 year of the discovery of the wrongful act or within 1 year of when symptoms associated with the misdiagnosis appear. If you've been injured by the negligence of a doctor or a medical professional in Georgia, it's extremely important to find the best medical malpractice attorney for your case as soon as possible. It takes months to gather all the necessary medical records and locate the medical expert that can evaluate and offer an opinion on your case. Our firm, Williams Elleby, offers free consultations in medical malpractice claims. Call today at 833-LEGAL-GA or 534-2542 to discuss your case. You can also find us on the web at gatrialattorney.com. On our website, we have online chats. We also have an online contact form. So you can call the phone number, use our chat, use the form, set up that free appointment. There's no risk to you, and we'll be happy to go over your options and help you decide whether you have a case that you want to pursue.